Hello, everyone. My name is Ariella Wagner. I'm the founder of SunRay Construction Solutions. We help thousands of general contractors, subcontractors, and suppliers secure their lien and bond claim rights. Today, we are lucky to have the amazing Chad Michaelson, who has been repeatedly included in the best lawyers of America and is an expert in construction lien law. So without further ado, I'd like to introduce the fabulous Chad.
Good morning, everyone. Thank you for that introduction, Ariella. My name is Chad Michaelson. I'm a lawyer in Pittsburgh. I specialize in construction law, and I've been representing contractors, subcontractors, and owners and some design professionals for over 20 years. Wanted to take about 15 to 20 minutes today to walk you through a step-by-step guide to ensuring that you're paid on projects for the work you perform. We'll do this at a pretty high level and welcome any questions in the chat as indicated here on the second slide. So happy to take questions at the end. If you want to put anything in the chat, we'll take a look at that when we're done. So there are three primary steps, in my opinion, to making sure you're paid for the work you perform. The first step is that you need to read the contract. You need to understand what your rights are to payment. You need to understand what you're agreeing to when you sign that contract or subcontract or purchase order. Second, you need to follow the contract. It goes to reading the contract and understanding the provisions that you comply with it to ensure that the owner doesn't have defenses to payment simply because you failed to include some documentation or failed to follow a requirement that you agreed to when you signed the contract. And third, you need to protect your rights when you are not receiving payment in a timely fashion, or when your work is complete and you're not getting paid. You need to take steps to protect your rights and not rely on the owner, simply to the owner or your contractor, your general, to follow through and make payment. So let's talk about those three steps in a little bit more detail. The first step is to read the contract. And I like to say, would you rather negotiate or would you rather litigate? Because if you don't read the contract, then what you have is a problem that is subject to terms that you don't understand or that you didn't pay attention to at the beginning of the job. And so you end up having to litigate what you agreed to. You'd much rather negotiate. You'd much rather read the contract and understand it and either at least know what your rights are or negotiate something that's more fair to you than what's in the contract. So what should you look for when you read your contract or your subcontract in terms of payment? One of the first things I look for or ask my clients to look for are provisions that talk about approving the work for payment. And one I see a lot is a provision that says the owner will approve the work, or you will perform your work to the owner's discretion or the owner's approval. I never advise my clients to sign a contract like that. Your obligation is to perform your work in accordance with the contract documents, not in accordance with what the owner wants. When you sign a contract that gives the owner the discretion to approve your work, it gives them a major excuse to withhold payment or to challenge your right to payment simply because they have a beef that might not be supported by the drawings or the specifications. The other thing to look for when you talk about approval for payment or approval of your work is a contract or a subcontract that inserts lender requirements, that you'll comply with whatever requirements the owner's lender imposes on the project. Typically, they don't tell you what those requirements are, and they oftentimes include inspections or delays in payment while the lender reviews things. The same issue applies. It could say, in the lender's discretion that the lender will approve your work, but you need to look for those kinds of provisions. You need to either negotiate them out or you need to understand exactly what those lender requirements are. Same thing for flow downs, right? Whether the owner's approval under the prime contract is a condition to payment. The other second provision you should look for relates to the timing of payment. And of course, that not only relates to how long do you have to wait, But the primary issue in subcontracts especially are what we call pay if paid or pay when paid clauses. Most of you are probably familiar with those, but there's a significant difference between the two. A pay when paid says that you'll receive payment within a certain number of days after the general receives payment from the owner, or if you're a supplier or a subcontractor, you'll receive payment within a certain amount of time after the sub receives payment from the general. Those are enforceable in Pennsylvania, and they're typical and not unreasonable, as long as the, say, general is paying you in a reasonable time, and as long as you understand what those time frames look like. There is a risk to you, of course, that if the general's not getting paid promptly, you won't get paid promptly either, but at least you understand the way it's going to work. The pay if paid clause is more problematic because it says that if the owner doesn't pay the contractor, that you won't get paid, whether your work was acceptable or not. Those clauses are problematic. I think those clauses are unfair and you should negotiate them out. Now, one middle ground sometimes is that, you know, if the owner doesn't pay the general for reasons unrelated to your work, you should get paid. If the owner doesn't pay for your work for whatever reason, because it doesn't comply with the contract documents, that's a different matter. But if you see a pay if paid clause, that's typically something that you want to try to negotiate. And when I represent generals and owners, I think I tell them it's not really fair to ask a sub or a supplier to not be paid for their work if, through no fault of theirs, the general doesn't receive payment. Next provision you need to look carefully at is retainage and understand how much retainage and when it's going to be released. In Pennsylvania, I'll talk later about the Contractor and Subcontractor Payment Act. All it says about retainage is that it'll be handled in accordance with the contract. So go back and read the contract, understand what you're agreeing to. The other thing to think about with retainage is what is retainage being held on? You know, more sophisticated general contractors will ask the owner or negotiate that retainage not be held on certain things like insurance or the contractor's fee or maybe general conditions, that it only be held on trade work. Certainly for your cash flow, it's worthwhile for you to look at the retainage provision and think about what is your retainage being held on. Also, obviously, it's very important to look at what the contract says about your lien rights. In Pennsylvania, a waiver of lien rights requires that there be a payment bond posted. And you should and can ask for the payment bond if you're being asked to waive your lien rights. In addition to having a waiver in the contract, the owner or the general contractor has to record a notice in the county where the project is located that says that these are the terms of our contract, these are the payment terms, so that the contract is available to everybody on the project, and that we have in fact posted a payment bond so that you can be paid. So there is some information available to you as a sub or a supplier if you have signed on to a job with a no lien agreement attached to it. Pennsylvania also has a state construction notices directory for projects valued over $1.5 million. And if the owner files its project in that directory as what is called a quote searchable project, which you can go to the website you see on your screen and you can search for your project. If your project is listed, subcontractors and suppliers must file a notice of furnishing or they lose their lien rights. Pennsylvania does not have a general notice of furnishing requirement like other states do, but 5+ years ago, this statute was enacted to create a notice of furnishing regime, but only if the owner lists the project in this database. So be careful to understand whether your project is in the database. That will need to be in your subcontract. There are certain provisions that have to be in the subcontract to notify you of this, but you can also find it out by going to that website. Last, I look closely at the changes clause. You know, the changes clause relates to how do you get paid for the work you're asked to perform that's outside of your original scope. Most subcontracts that you see will include waivers of the right to obtain payment for certain kinds of additional costs. They might tell you that you waive any kind of costs for acceleration or any kind of cost for interference with your work or for delays, or that you waive the right to extended general conditions or any kind of money, and that you only get a time extension. So look carefully at those clauses. Also look carefully at what you have to do to notify the owner when you think that you're being asked to do extra work. So look at the changes clause and look closely at how it requires you to waive rights. Step 2, follow the contract. So after you've read the contract and you understand what's required of you, it's much easier to do the things that are necessary to get paid in a timely fashion. That starts with your monthly invoices or your applications for payment. Those best practice obviously doesn't work on every project, but to do pencil copies and to be able to communicate and say, here's my payment application, does this comply before you submit it, avoids the problem of I submit an application for payment on the last day that it's due, and 14 days later I'm advised that there's an error, or 10 days later, I'm sorry, I'm advised that there's a notice of an error. And then I have to resubmit, and it restarts the clock on when I get paid. So be careful about your payment applications. Collaborate with your general or with your owner to try to make sure they're in accordance with the contract. Make sure you've provided all the supporting documents, lien waivers in particular, which I'll talk about in a second. And be aware that Pennsylvania's Contractor and Subcontractor Payment Act requires that either the owner or the general contractor give 10 days written notice of any error in the application for payment. If they do not do that, they waive the right to assert the error. So you must receive 10 days written notice. If you hear nothing about a payment application for 10 days, under Pennsylvania law, it's deemed accepted and it's deemed payable, and the owner or the general cannot allege it's not being paid because of errors in the submission. Look carefully at the conditional lien waivers that you're required to submit. Those need to carefully account for prior payments received. You don't want to be waiving rights for payments that have not come yet. So if you are receiving payments, if you're submitting a payment application every 30 days with a conditional lien waiver, but you're not getting paid for 45 or 60 days, you can't be signing a lien waiver that says you've received payment that you haven't. So be very diligent about signing conditional lien waivers and checking the amounts of what you've actually received when you submit the lien waiver. And be very careful about noting in your lien waivers any pending claims. Typically, a lien waiver says, I have no claims. I have waived any right to additional payment as of the date of that. So if you are submitting emails or notices to the owner looking for additional compensation, but you sign a lien waiver, you can waive those rights. So be careful about pending claims. Look at the provisions for processing of payment, obviously the timing of when you have to submit things and the requirements for the applications for payment. But in Pennsylvania, again, under our Contractor and Subcontractor Payment Act, there are 2 written notices that have to be provided if there are problems with a payment application. First, within 10 days is the notice of an error. That's what I talked about a minute ago. Second, if the owner is going to withhold payment for a deficiency item, for work that you're submitting for payment that they claim is defective, or if they are withholding because of notice of a subcontractor or supplier claim, they have to give written notice of that withholding within 14 days. Otherwise, they waive that right to withhold. So if you submit a payment application and you hear nothing from the owner for 14 days, the owner technically does not have the right to withhold anything from that payment application. Finally, follow the contract with respect to notice of your claims. Notice that you are doing extra work that you need to be paid for. There are significant differences there between private and public projects. And I'll note that in Pennsylvania on public projects, you really need to get a signed change order by the authority, for instance, a school board, before you do the work. I know it's difficult, it makes you seem like a troublesome contractor to not want to perform based on the engineer's authorization or some other written authorization, but there's law in Pennsylvania about public authorities approving change orders that the engineer can't do it. So be very careful on your public jobs. Finally, and this is where Ariana and SunRay come in, is to protect your rights when you're not being paid. In the instance of slow payment, you need to look at our Contractor and Subcontractor Payment Act. But the first thing that says is that the owner or the general shall pay in accordance with the contract. So what was step one? Read the contract. CASPA doesn't help you if your contract says you don't get paid for 60 or 90 days. What you agree to trumps whatever is in our Contractor and Subcontractor Payment Act. But if there is no provision in the contract, CASPA says that payment from the owner has to be made within 20 days after it's due, after you submit, and that payment from a contractor, i.e. to a subcontractor, must be made within 14 days after you submit or after it's received from the owner. In terms of protecting your rights, think about your change order disputes. The owner must pay undisputed amounts. They can't withhold money that's not disputed simply because the total amount of a payment application includes disputed change orders. So make sure that you are communicating about those, that you have emails or letters or other notices saying, you have not approved this change order, we have a claim for this amount, that you don't waive it with respect to signing waivers, especially when you receive final payment. What if retainage is not forthcoming? The only thing that our CASPA law says is that you're entitled to retainage 30 days after final payment is due. But the contract is going to have a lot of conditions precedent to final payment, things you have to submit, work that has to be approved, and final payment isn't even due until after the punch list. So this goes back to step one. Look at your contract. What does it say about retainage? Finally, if you are not receiving payment as the job comes to a close, pay careful attention to your lien or bond claims. In Pennsylvania, liens must be filed within 6 months from the date of last work on the project. That does not mean punch list work or warranty work. It means the last work within your scope. So typically, you need to file within 6 months of the date of substantial completion of your work, if that's certified by a certificate, or the date that you demobilize once your work is complete. If you are a subcontractor or a sub-subcontractor, in Pennsylvania, lien rights only go down 3 levels: a general contractor, a subcontractor, and a sub-subcontractor or a supplier can file liens. The latter two, if you, the sub or the sub-sub, must file a 30-day preliminary notice before they can file a lien. That means they only have 5 months to begin the process of filing their lien. They have to give that 30 days notice. They have to follow very specific steps to serve that notice on the owner, and then within 6 months have to file their lien claim and have to also serve that on all the parties in accordance with the statute. If you miss any of those steps, you will compromise your lien rights. Finally, on jobs where lien rights have been waived and where there is a payment bond, pay close attention to the bond requirements. Again, best practice, get the payment bond up front. When you're not getting paid at the end of the job, most people have been in the situation where an owner or a general is reluctant to give you the payment bond. And you have no idea whether that payment bond says you need to file a bond claim within 30 days or 6 months or 1 year, but the bond will have timing and other requirements that you need to follow. So pay close attention to what's in the bond to make sure that you don't lose your right to get payment under a bond if the general or the owner fails to pay. All right, there is a lot there, but I just hit 20 minutes and I don't want to take up any more of your morning. So I don't see any questions in the chat, but I'm happy to take those. And our contact information is here and on this. And I guess let me turn it back over to Ariella to close things out.
Absolutely. You know, we do have these questions that pop up, and I know that after this, if anyone does have any questions, I think that you absolutely should be reaching out to Chad for your contracts if there's any dispute resolution. But a question that comes up all the time is, I'm owed retainage and they're promising me that they'll pay me, but I'm owed this money. Should I lien the property?
Yeah, and the answer is absolutely. You cannot miss your 6 months based on promises of payment. You have no choice.
Right.
Right.
So, and that's a big point because people miss that deadline all the time because they think that they're owed the retainage and therefore that extends their timeline, but that absolutely doesn't. Another question is, where people go, wait, my retainage is 10%. Should I lien for my retainage as well?
Oh, absolutely, right. Your lien is for the value of any labor or materials you provided. So your lien includes the entire amount you're owed.
Awesome. So when we're talking about commercial projects, how essential, so that 30-day notice that has to be sent, your preliminary notice, and then your your commercial projects. I think that one question that came in is if you could clarify that.
Sure. So the subcontractor's preliminary notice, the idea is that if you're a general, the owner knows you're out there and knows you might file a lien. But our lien law says if you're a sub or a supplier, you've got to give 30 days notice before you can actually file your lien. And that means that if you have to file the lien in 6 months, you can't wait 6 months because you would have missed out on the notice requirement. So we always back up to 5 months, preferably more than that, because you have to mail it out. You have to make sure it is actually received. But the preliminary notice is fairly simple, and it's a form I know Ariella's company can help you prepare, but it's a fairly simple notice to the owner and to the general contractor saying, I am unpaid, I intend to file a lien, and here's the amount of the lien.
Amazing. Well, thank you so much. What a great webinar you have provided. Again, just fabulous. If you have a moment and you'd like to give us a review on our webinar, you could just point your mobile phone to that QR code and we'll take maybe 3 seconds. And then again, you'll have all of Chad's contact information. And after this webinar, if you have a question, my apologies, Chad. Yes, we have other webinars coming up. So if you'd like to give our next webinars, Chad, share that with our audience.
Sure, I was just working through the couple last slides here, Ariella. Yeah, so we're going to do one on May 11 that talks more specifically about some of those questions about what happens after you record your lien and what do you have to do to actually get money in your pocket. And the August webinar will focus a little more on lien waivers, right? Don't sign a release until it passes this checklist, and I kind of touched on those earlier in this talk.
We have a really great question that actually came in, Chad, if you don't mind, which is there's so many misnomers because a lot of the audience that are on our webinar, they're actually work in multiple states and using the correct terminology for them. So we're calling it in the state of Pennsylvania preliminary notice. So here we have the question is the preliminary notice that you refer to sounds more like an intent to lien. Wouldn't the preliminary notice be the notice of furnishing?
Right. No, two different things. So the notice of furnishing, if it's a shared, a searchable project, a registered project, notice of furnishing comes before you do your work. That's the notice that you are on the project, okay? The preliminary notice I mentioned is in fact called in our statute a notice of intent to lien. General contractors don't have to file that if you have a direct contract with the owner, but subs and suppliers do. So that comes when you have not received payment. You serve the notice of intent on the owner and the general contractor saying, I am unpaid and I intend to file a lien.
Right. So the person that asked that question in the application, it will say intent to lien. It won't say preliminary notice.
Right. That's
Perfect.
Correct. Yep.
Okay. Then our next webinar is don't sign a release until it passes this checklist. And we know, I'm sure you have nightmare cases with that, Chad, of people that sign through dates and finals inaccurately. So we're all looking forward to that webinar for sure.
All right, well, I'm happy to do it and always happy to take questions.
Very good.
Put our contact information up again.
Very good. Well, again, thank you so very much. Such a great webinar. And everyone else, I wish you all a sunny day.